evening everyone, I am Lavanya from Lexis and Company as an intern. Today I'll be talking about how to file a criminal suit in accordance with the CRPC, which is the Criminal Procedure Code of 1973. The step 1 which is there is the filing of FIR which in the cognizable offence, which is first information report, which includes all the information as to when and where the act took place and all the information with regards to the parties. There can be few examples like kidnapping, theft, criminal breach of trust, etc. The police officer in charge of the designated police station is required to reduce the above mentioned information that in written manner specified by the state government. Additionally, the said officer must read the complainant the contents of the writing and obtain his or her signature. Step 2 is the investigation by the police. Step 3 is reporting a non-cognizable offence by the police. When a non-cognizable offence is the subject matter of information, the officer in charge of the police station where the offence was committed must record the details of information in the book that the state government has mandated and recommended the complaint to the magistrate. Non-cognizable offences are the offences where a police officer has no authority to investigate without any search warrant. Step 4 is filing of the complaint before the magistrate directly. The magistrate has an authority over the alleged offence and may be approached directly by the complainant. The magistrate will put the complainant and any witness in attendance and examination under oath, wherein the statements made are converted in writing and the signatures are obtained on the document. Then is the stages of the proceedings. The court may convict a person on his plea under section 253 CRPC. The provision has been inserted into criminal law regime for speedy delivery of justice. Then we have the chief, the cross and the re-examination. The whole process is known as examination of chief. After this, the court records the statement of the accused person under section 313 of CRPC. The accused is given an opportunity of being heard and explain the facts and circumstances of the case. Usually the burden of proof is on the prosecution and defense is rarely asked to present evidence before the court. After examination of all the evidences and relevant facts and circumstances, the court decides upon what questions are to be addressed during the final arguments of the case. The public prosecutor and defense counsel both present their arguments to the case over the disputed issues. The judgment may be clear, precise. It should state these facts of the case, arguments presented, acquittal, conviction of the accused, and the grounds for the same. After judgment is delivered by the court, the aggrieved party may file for an appeal. The aggrieved party may alternatively also file for a revision petition to prevent a faulty judgment from being enforced. The last stage in the execution of the orders is the orders. The stage of execution is when all the remedies of the appeal, revision, etc. are exhausted and the decision is final.